Hi, everyone. This is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for August 4th of 2025. Sorry about the delay in getting started. YouTube wouldn't let me sign in. I had to verify and re-verify and run around the house and try to find my iPad.
Nothing's easy.
Unbelievable. So modern technology. But Brad, go ahead. Take us
All
away.
right. So this first case, I'm trying to decide whether it's disturbing or whether I'm going to play lawyer and say, okay, I understand it, but it's disturbing. But let me caution everybody. I think the reason it's disturbing is because this case only focuses on one specific portion of this claim. So I'll start with that. It doesn't focus on a lot of other reasons because this guy should win.
It's
Just
a
why
narrow,
he
it's a
should win.
narrow issue, but it's the
Narrow issue. So here,
FDNY
yeah, so
vaccine.
here's the case, right? The case we have a federal judge that just dismissed one of the claims, which is a constitutional claim. It was brought by a disabled former FDNY firefighter. He alleged that he got the COVID vaccine. It made him super sick, right? I think that it required
Yeah, we covered
hospitalization.
this. We covered this
Yeah,
earlier. So, yeah.
we did. And he then is told you've got to get the vaccine if you want to keep your employment. So, as the court says, you have a choice.
He's got to get the second shot.
Get
The
the
first
second
shot
shot,
made
or
first shot made him sick. He told them it made him sick. They said you still got to get the second shot.
right. And they talk about, well, the accommodation, which seems ridiculous to me. The accommodation is don't get it, lose your job, which I don't understand. But
Well,
in any
there
event,
was another accommodation, but it had to do with getting some sort of a uh, specialist in what do you call it? Like that type of
yeah,
response, that
not the
anaphylactic.
immunologist, but yeah, or
Yeah.
I think it
Yeah, I
was
think they wanted him to get some sort of an immunologist involved or whatever.
right, to give them
And,
an opinion as to whether this is really causing it and what could be done. In any event, he gets his he
allergist. That's what
allergist,
allergist.
allergist.
That's, yeah,
Yes,
yeah,
I should know that.
yeah.
So he said, listen, they said you got to complete the vaccination. He said it's going to make me sick. He, in fact, I think does it right and gets
He-
super sick and
oh yeah,
hospitalized.
he got myocarditis, which is that the concern with the vaccine for some people. Yeah.
Well, not the federal government's concerned. They're running television ads saying it's perfectly
Well,
safe, but
let's not get into the politics of it, but the the
So,
the,
right. So
the
he
medical
he
part. Yeah.
he sues under the 14th Amendment,
Mhm.
an issue now that's very dear to me in my personal trial or my legal trials.
Yeah.
And he has to prove that there is what's called a substantive due process right, not a procedural due process. Procedural due process is easy to explain to everybody.
Right.
Procedural due process is you get a notice, you get a hearing, you get procedure that's due to you under the Constitution.
And they
Um,
gave him all of that.
and they
They
gave him all
gave
that.
him all of that. And the big thing when I lecture on this, one of the points about what's the difference here is that there are certain things that government can do that even if they give you the procedure, there's something still fundamentally unfair about the way they went about it. Even if
Correct.
they give you the hearing, it
Right.
still is fundamentally unfair. That's substantive due process.
And as the best example of that, the failure to be given a jury trial has been, at least for now, held to be a substantive due process, right?
Yeah.
And it's easy to confuse it with procedure, like, oh, as part of the procedure, I want a jury, but
Right.
here it's substantive. The right to a jury trial, for example, would be substantive because it's in the Constitution. So I say. In any event, so here the court holds, and this is what's kind of gut wrenching, right? Because they kick him out of court on this claim, not all others. The rest go back to
Right. He
state
brought,
court.
and let's make it clear. He made a number of claims, most of which were either state law or based on city policy or city ordinances. So he still has some avenues to pursue. This was the one that got him into federal court, which was substantive due process.
Right. And here's the thing. So they send him back to state court, right? And they kick out saying there is actually no fundamental right to be free of vaccinations or to be free of harm caused by vaccinations. And that's where I disagree. Yes, there
Well,
is.
I don't, because I think if you change the facts from the C word here, change it to something like polio, change it to something like Ebola, or something which the plague, which could, and that's not a virus, but the things that could potentially transmit to other people and make other people sick. I think that's the court is looking
greater
at
public
sort of
health
a broader,
good.
exactly. It's like the same issue. I don't want to get sidetracked here, but same issue comes up when somebody has a fire in their house and they have a house next door on either side. They have a house in the back, a house across the street, and they tell the fire department, you can't come in.
Right.
Okay. We're not worried about saving your house. We're worried that if we don't put it out when it's small in your house, it's going to spread to other people. So therefore, yes, your house is your castle. Okay. And that's where you have your most Fourth Amendment rights. But if you have a fire in your house, we're coming in to put it out so it doesn't spread to other people's houses.
Right. Or
think,
look, if you want to be directly on point, go to schools, elementary schools, public schools. The courts have all held they have the right to tell you that you're going to get vaccinated. The problem I have is this isn't that. To me,
well, and that there's a
case is
factual
different.
question on that, and I agree with you on that point. That there's a factual question about whether this particular disease is the one that they should have gone to the ends of the earth to address.
Right. And look, at the time, we didn't know, but that's still not my issue. My issue is this is making him sick.
Right.
He's right. So their response is it doesn't matter why you can't have it, whether you don't want it, you don't believe in it, religious or disability in this case. And the court says it doesn't matter. You have to have gotten it. Right. And the employer has the right to say you do. The reason is unimportant. I'm okay with even that. Right. That's pretty much the court's holding. But to say in this instance that you can be terminated, that's what I am more.
I agree. I agree with you. I agree. And I think substantively, that's where we agree. The narrow issue in the case, though, is whether or not there's a fundamental constitutional right. Because if it applies here, how do you distinguish here from the Ebola case or some of the other polio or the school cases or some of the other issues? And I think that's where the court is struggling. And I can also see this being reversed on appeal, by the way. It may, but I think that there's a fundamental issue. We're also looking in the rearview mirror at something that we know where it ended up.
Right.
And the court, I think, is trying to say, no, wait a minute. We can't look in the mirror at this. This maybe shouldn't have been adopted as a policy, but the bottom line is it was. And is it the type of thing that government is able to do to its employees? So
under the Constitution. Now, right.
Exactly. And I think he's right. And he still has he has a disability claim. The thing that, there's something that pisses me off in this. Okay. And it has to do with him being denied a disability pension. He was granted an ordinary disability pension, which is not a line of duty pension. Yeah. He was ordered by the fire department to undergo this process and got sick as a result.
That is line of duty.
It should be an ordinary disability. Now, one of the ways that they've sort of gotten around that is they say there was no accident. Okay, it was not an accidental. He didn't fall down a flight of stairs or have a room flash over on him.
But that's like saying you were in training, you got disabled. This is the same thing to training, right? In advance of the actual emergency, you're taking some precaution. Training or vaccine, you're right. You're 100% right.
Yeah, but there should be some way to address the injury that he has sustained.
Right. Okay. But if the government came out, and we won't go too much further on this, but if the government came out and said, listen, we have a poison we want to give you, and the poison is rationally related, right, a very low test, which is what was here, to some purpose, but we want to poison you, and listen, you're going to lose your left arm as a result of it. You have to do it or we can terminate you. There, the government would be saying, wait a minute, you can't knowingly harm someone. You can't. How is that different? And so where's the line? Because the government said this is a valid vaccine.
I think we'll go back to was it first year law school, second year law school, and constitutional law. We took it first year, con law, and maybe it was second year. I don't remember.
First year.
But
Well, for us.
bottom line is, it's what level of scrutiny are we going to give this issue? Okay, if it's a fundamental right, and this is what he was arguing. Pastrana was arguing that I have a fundamental right not to be vaccinated. And the court said, no, there is no fundamental right. Is there a right? Yeah, of course there's a right. It's a personal right. Okay. But here's the thing. If it's not a fundamental right, the courts apply rational basis review. Okay.
Very low standard.
Now, very low standard. If it's a fundamental right, then there's a level of scrutiny that we call strict scrutiny, which it's almost impossible, not impossible, but almost impossible for government to justify. It's got to be compelling. It's got to be narrowly tailored. It's got to be all these things for strict scrutiny. And the court said there is no fundamental right to that. Now, my question is, substantive due process is still connected to the 14th Amendment.
Oh, yeah.
And the 14th Amendment says life, liberty, or property.
That's where I'm getting it. Life.
Well, that life is a fundamental right. Okay. Property, you're taking his job away. That is so again, I have some concerns about the way the court interpreted it. I think I agree with the court to the extent that they argue there is no fundamental right to not be vaccinated, because otherwise we couldn't have school requirements and people coming into the country. I mean, if you're going out of the United States to certain countries, you have to get vaccinated.
Right.
They
Or they
will
don't have
not
to
let
let
you
you
in if you haven't been vaccinated. Okay. And we should be in a position where we can do the same thing. But if it's a fundamental right now, that raises a question. Okay.
Right.
So the court said there's no fundamental right, but I think there is a due process right in the 14th Amendment as to property. And fine, he doesn't have to, but you can't take his job away from him. Okay. Now maybe you can, put him on suspension without pay until, and in hindsight now.
But that's where the ADA claims or the state discrimination claims are going to
And I
come
think
in.
those are stronger claims under the disability discrimination.
Right. And that's where I was saying that I was pissed off about the holding, because the action is wrong. Firing the guy who's willing to get the vaccine, but it doesn't it makes him sick. And then to say, well, there's no way to accommodate him. Sure, there are ways to accommodate him.
I think sometimes what they try to get out of us as lawyers is that, or at least to recognize it, is when you feel like there's a manifest injustice taking place, and we try to twist the law to try to address that. And what we should be doing is exactly what the court in this case did: really analyze it. Separate yourself from what you feel is right and wrong. Look at the law, apply it. There's other laws and stronger laws that are probably going to give him some remedy, I would hope.
I believe this will come down to under the state law, state discrimination rights. They're going to say you could have worn a mask at work 100% of the time. You could have.
But that's getting into the rational basis part of it. Was the city justified in this policy? And, I don't think we've seen very many cases where that's been seriously challenged, the city's right to impose a vaccine.
No, to the opposite. It's always been upheld, saying the city, the employer has the right.
We did come across one, but it was kind of an outlier case that it had to do with you're allowing it for this, but you're not allowing it for that. So, but
anyway, we'll see where this comes in the state. And that's going to go on for years, frankly. The state courts, my bet.
And we'll see if they choose to appeal it to the Second Circuit, and see what the Second Circuit says about it.
If I was them, I wouldn't appeal the decision, because it's right. It's just gut-wrenchingly wrong, right? It's legally right, but it's gut-wrenching. But again, they have the state process. That's where
it's like trying to evict the old woman out of her house on Christmas Eve. There's something fundamentally wrong with it, but if she hasn't been paying her rent, whether it's Christmas Eve or Tuesday in September, right?
Yeah.
So.
Okay, let's go to New Jersey. This is a great case. This is just seriously, vindictive case. I mean, if so,
If the facts are as
if the facts are as the court recites them.
right.
So here's the short of what we have. We have this. It's a little confusing, but I'll try to make it simple. We have, or the highlight points anyway. We have a former captain of a fire department who's also a member of a first aid squad, a rescue squad of, I think it's separate from the fire department,
Correct.
right? But they all work together. And what happens is the first aid squad is going out of business. They're going to sell all their stuff. And if this was New York, I would tell you they have to get Attorney General approval, but this is New Jersey. So I don't really 100% know the process to dissolve a not-for-profit corporation, but they're going to get rid of all their stuff. And they're getting rid of one of their rescue trucks. And so on the day they're supposed to deliver it to the buyer, he goes and fills it up with gas. Very publicly, right? He uses the key fob and the fuel of the department, the government fuel, right? And the borough, he gets in there with a key fob or something. There's no secret. He's not sneaking in the middle of the night, right? And it's clear he's filling up the rescue squad, or squad or whatever it is. But then, which goes that day or the next day to the buyer. And so what happens is they file a police report, right? And they ultimately,
it's a little bit more than that, because what happens is there's this animosity that apparently develops between the first aid squad that's going out of business and the borough with regard to their property. And the borough wants to buy the $1.5 million worth of property that the first aid squad does, and they don't want to sell it to them. And so they go out to bid, they find a high bidder, and the borough is upset. So they turn around and start setting the stage so that they can take the property by eminent domain. That causes the buyer to back out. And so now you've got this, and then they come out with some sort of a referendum. They want a referendum vote on the whole thing. And the bottom line is the first aid squad people are making life difficult for the borough. And now yes. We're at the point where you were saying they come up with these criminal charges.
Right.
Yeah.
So now, right. With that background, now there's the basis of the animosity. And so they get him charged with, they have him arrested and charged with theft for that. And it was, what's the exact, $56.64 worth
Unbelievable.
Right. Now, that's not what the lawsuit is, right? So the county prosecutor dismisses the charges against plaintiff, right? The primary one being theft of the gas, the others related official misconduct. So the county prosecutor, right, gets rid of it. Now, I thought this is where the case would end, but so he could now commence as a civil action suing, right, the department or
the city, the borough sues the borough. The
Yep.
borough and the police officers that were involved in the decision making about charging him.
Right, and the question he sues under malicious arrest, not prosecution, malicious arrest, false arrest, and it's all the same question: false arrest, malicious prosecution, conspiracy, First Amendment retaliation, abuse of process, all under the basis that you didn't have probable cause to believe a crime was committed. And the judge agrees and is allowing this to proceed further. They tried to get it dismissed, and the judge says, no, there was no probable cause here, and you shouldn't have been arrested, and this is going to go forward. At this point, they should be settling.
I would
right. We should not see a thing about this other than in a settlement agreement later.
Yeah. But this, as alleged, and again, these are the allegations. The court has sort of confirmed at least the allegation part of it. They haven't had a factual hearing on it to determine it, but the allegations are such that this is an abuse of government authority, that this is vindictive, process going after a particular person. And maybe this guy's a pain in the butt. I don't know. Maybe he's a pain in the butt. Maybe he unnecessarily caused the taxpayers to lose money and created headaches and a lot of other things for the municipality. But you can't use the strong arm of the police to go after somebody for things like this.
Yeah. And the way the judge writes the decision is is saying, listen, I'm telling you what is going to happen to you if you don't resolve this, right?
Yeah.
The way I read this, he's saying, this is what it looks like to me. So, right, no probable cause. It looks vindictive. It looks I mean, so this thing is settling. We're not going to hear another thing about it, other than
Well,
maybe.
again, assuming that they can prove what they've alleged, the judge hasn't had hearings on all of this,
No, he's just giving an impression, but
but
it goes
that's right.
further because it could appear that.
Right.
But come on, and it is. You know, it'd be one thing if he snuck in the middle of the night, jumped the fence, unlocked the thing, drove in. Come on.
You know, my department has fuel tanks that we use, but we have another agency in town that uses the same fuel tanks. And when they come in, they write down how many gallons and all that, and we send them a bill at the end of the month. And I'm assuming that there was something similar. So how is that stealing?
Right.
And that was his defense. You send us the bill, we pay it. I mean, it wasn't surreptitious. It was.
Right. Stealing is you don't want to get caught. It's not, hey guys, I'm stealing your gas, just so you know. I mean, I'm going to write it down. Anyway, crazy tough. Okay, let's go to this is a good one to start with. If true, if true, if true. We don't know. This is just a lawsuit. We're going to Washington. We have a female former fire chief. She her department was combined into two, and she was, you know, reassigned or whatever, but she's alleging sex discrimination, sexual harassment. And let me just say this. If you are going to do something that's alleged like this, and I'll get into it, well, I don't want to say you shouldn't be so obvious because don't do it at all, right? Don't discriminate. But certain things here look so bad. So here's what looks, if true, very bad. So she alleges that from the beginning of her time with the merged department, she was discriminated against. And she says based on her sex, she said she was given a windowless office away from the other deputy chiefs. Now, what I didn't see in there, but I presume she says, who are all male. I'm presuming all the other deputy chiefs are all male. She's female. She's given a vacant office, or she's given an office with no windows, despite that there are windowed offices available, right? And then she said she's given one of the department's oldest vehicles, despite her position requiring extensive travel. And then she says she's been subject to heightened scrutiny and micromanagement compared to her male colleagues. First time she mentions, I think, her male colleagues. But she says she reported her. This is you and I talk about just in time all the time, or just, you know, the time relevance. Something happened, and then was it 3 months, 4 months, 6 months, a year, 5 years later when they retaliate? And courts normally look at this and say, what do you claim was the retaliation, and what is it based on? How long ago in the past? And normally courts say more than 6 months is too long, right? That we can't link the action and the retaliation. Here, allegedly, she complains and to the HR department, which is what's hard to believe. I'm not saying it's not believable, but it's hard to believe. She complains to HR. The HR allegedly tells the chief about the complaint, and the next day she's told, here you go, here's a severance agreement. And she's being allegedly pressured to resign. She refuses to resign. They started documenting complaints against her, allegedly, and then she's soon thereafter terminated, citing over a dispute whether an email had been sent. This, if it is true, is so typical of how these things happen. And to your and my point we constantly make, this is so obvious to anyone who sees it. Why would you do it? If this is true, but this type of allegation is not, right? We could take some of the facts out and they'd be similar to a million that we've covered.
Yeah, no, would. And I think there's another fact pattern that I'm not saying it's connected here, but I think it's worth talking about because chiefs, guys and gals, whoever is the chief, need guidance in this situation. And the situation is where you have someone who is underperforming, and you've got complaints and you're dealing with them and you're trying to keep them, you're trying to deal with them. Okay. That's from the fire department's perspective. From the employee's perspective, same person, but the employee's perspective, they feel like they're being picked on. And now they go to HR, and the department was just getting ready to move on the person. And now the person goes to HR. Now you're a little bit of a chess match here. What does the department do in that situation? That's why you've got to document things, even with someone who you value and you plan to keep for a while, you've got to kind of get their behavior to correct a little bit. You've got to document what you received as a complaint, what you did in response to the complaint, because then if they do in fact interpret your coaching, whatever it is you're trying to do, as hostile, and then they go to HR, you're at least 6 months, you're almost not able to do much with them, or otherwise it's going to look like retaliation. That is a very common move, by the way, that employees who have previous experience working and maybe having problems at that job learn to do, which is go to HR and complain that you're being picked on.
But the problem here, if the allegations are true, is that they had just merged, and shortly after, whatever shortly is, days, weeks, months, we don't know. So go on the presumption that either they just didn't like women. I'm just throwing out a million possibilities with the merge department, or she came with a history. They warned the new department about her. And again, I'm making this up. I don't know. Right. But they warned it. And so they started with a bias against her. Now, if you have a bias against somebody for the exact point you said, don't give them a reason to throw this in your face. If they had simply not done anything about her office, give her the same office as everyone else, give her a normal car, because they've got to, under the McDonnell Douglas test, they now have to come forward and say, the reason we did these things is because, well, that's two of these are hard to justify unless, hey, we had no other cars, we just merged, we don't have any extras, this is what we gave her. Okay, fine, right? It was the only one remaining, fine. But if there was a newer one available, then they're in a little bit of trouble. And there was no reason for them to go this way. If she's probably not contracted, I don't know, but I'm assuming she's not contracted. Maybe she's at will, right? And they could just get rid of her. They could have, or suck it up. But when you start showing your distaste for somebody through these allegations, it's not going to help you later on. It looks discriminatory. And it's hard to argue we just didn't like the person because they're cantankerous or whatever. Because, especially with the circumstantial evidence, how many males were there in leadership positions? How many women are in leadership positions? How many women in the department? It starts, if the merged department only had one female chief, being her, which is probably likely, it doesn't look good to a judge or jury. So, anyway, don't do this stuff. Whether it's true or not, don't do it.
Well, I know mergers. I've guided some chiefs through some mergers, both the person who comes out number one and the person who comes out number two. And there can be problems, between them. They both were chiefs, and now one of them's going to have to be subservient. And that dynamic can create some problems as well.
Yeah, I remember walking into a merger I just completed in New York with 4 fire departments. And I walked in with my associate at the time, Zach, and I said, I'm going to tell you right away, watch my one question, I'll tell you whether this is going to work or not. And I was expecting it to fail immediately. And I said, understand, once you merge, there can only be one the chief. Who's it going to be? And both chiefs pointed at the other person. I'm like, this merger is going to work because nobody wants the job. So, anyway, okay, let's go on. We have another federal court decision. And this is kind of a minor, it's not a minor issue. It's a novel issue you and I don't see. It's not like this groundbreaking type of case, but we had an employment discrimination case. And there was a mediation about benefits, etc. There's a mediation. The parties agree to most, but not all of the major terms. In law school, we call this a meeting of the minds. And here's the rule that the court goes back to. Talk about first year law school, which is there can be no contract where, one, there was no meeting of the minds, but it's a meeting of the minds on all the material and most important facts. You can't have a contract to sell a house if you couldn't agree to the price, but you agree to everything else. And here, there were a lot of very substantial issues which they didn't agree upon. However, one party said, wait a minute, you did agree, you have to fulfill the agreement, because what happens is they have this mediation, they agree to most of it in concept. But as always happens, when the lawyers start drafting things, they start realizing, oh, we didn't address this issue or this issue, or what about this question? So they send back counteroffers. In one instance, they said, we agreed on this many sick days or something. And then they sent it back and said, no, we're reducing it. This is what we now propose. And so she said, look, you went back on a contract, which was our verbal agreement, verbal contract. We had it to mediation. Even the mediator, who maybe a lawyer, maybe a contract lawyer, probably not. But even the mediator's like, oh yeah, they agreed on everything. But the court reviews it and says they didn't agree on everything. There are a lot of material terms missing.
Yeah,
and
that,
to me,
there's a little bit in the weeds here. They agreed, at least there was a telephone conference where the parties agreed to 2,200 hours of sick leave. They were going to extend to him 2,200 hours of sick leave that would bridge him to retirement at 25 years. By the next day, they had done the calculations and realized he only needed 1,375 hours. So it got him to the same point,
but it changed.
But there was a difference. So what was the key factor? Was it the total number of hours that was the key factor? Was it the getting him to 25 years of service? And so and the parties disagreed about that. But that's a pretty fundamental difference.
Yeah. And look, maybe the one party said, well, you're giving me more than I deserve, so I'll accept that in lieu of something else.
Right, in lieu of a larger cash settlement.
Right. So it matters. So the judge nailed this one. They got it right. But it's funny because it's just a basic first year law school case in a sense. But I thought it was a good point. Okay, let's see. Now I got to get to our next one. So I'm getting there. Now you present, this is a really good, is this out of your book? I mean, I keep thinking like probably is. So we have two opposite cases, opposite results dealing with the exact same issue. The issue is whether disabled firefighters qualified for an accidental line of duty pension, right? Or a non-line of duty pension, which is very significant, right? And you talked about it in the first COVID case. So here, let me just kind of show, we can get into them, but in the one instance, right, with Brookfield, is that Illinois? In the one instance, we have a firefighter who claimed that they were hurt lifting a stretcher and claimed that they were disabled as a result of that, but didn't report it timely, reported it much later. The judge says, wait a minute, nobody on scene verifies any of this, that you were hurt lifting a heavy patient on a stretcher. You had a previous back injury, which you did timely report. So you certainly knew how to timely report these things. And so the board, having found that your demeanor wasn't, like somebody who was injured in the line of duty and nobody could account for, look, we were all there, right?
Your testimony was not credible.
Testimony was not credible. Yeah.
We're not saying you're a liar. We're just saying your testimony is not credible.
That's a legal way of saying you're a liar, right? No. But so there they say not line of duty injury. It's right. But then you have another one who you do have in the FDNY where you have kind of this chronically injured person. And when I saw that he's got a long history of injuries, knee and other, I thought the court was going to go the same way as the first one, but they don't. Right here, the court says that the FDNY's denial of pension benefits, in line of duty pension benefits, was arbitrary and capricious, the standard for this type of thing. He said the board had no rational explanation, finding that the injury was unrelated, right, to being at work, and so they said, you got to give them benefits. Here, the injuries. And they said there was credible evidence that his injuries were line of duty. I'm trying to see what his injuries were, though.
Back and knee, I believe.
Back and knee.
12 involved his lower back and 9 involved his right knee.
Yeah, 14 total related injuries, right? With the last one being in August of 19. So, and look how long it takes to get here. I mean, it's 5-6 years to get to the first round decision, right? This could keep going higher, but there you juxtapose it.
Mhm.
there's evidence of it, right? And the FDNY ignored the evidence, and the court said you had credible evidence that his injury was related to on-job
Yeah,
injury.
so generally, bottom line is generally the pension board is going to have a lot of discretion, and the courts are going to give deference to that. But where the decision is just it's irrational. Like
Right.
where did you come up with that there's not enough that he was injured in the line of duty? It's all documented. Whereas in the first one, I do want to correct one thing that we said.
Yep.
When we say that someone is not credible, there's reasons why someone may be not credible without them lying. It's one of the classes that I teach
Yeah.
too. So there's reasons why. One of the reasons why someone may not be credible is because they're lying, but there's other reasons as well as far as recollection, as far as balancing, who's more believable, who's a neutral witness versus who has motive in terms of going one way or the other. So there's a lot of reasons. We're not saying somebody who's not credible is lying. We're just saying that they're not credible. So
Right. Fair.
don't send us any hate mail.
Yeah, we
Thank
got
you.
enough.
Yeah.
Let's see. That is one, two. Is that all of them? I think that is all of them.
I think that is. I think
Very good.
that's
That's a
5. Yeah.
good week. And I again say, if people will listen to this regularly, and
Mhm.
many of you do, obviously, you really start to learn a lot about the law. I mean, I really
Mhm.
think this is a very long way to get to a lot of very realistic understandings of how the law plays out, what to do and not to do. And, one of the cases today is a good what not to do. I just think it's a great professional course,
Mhm.
frankly, if somebody really wants to self-study by watching us. So thank you to everybody who does, of course, and you'll continue with the please subscribe. But I really hope and believe that we're giving a lot of value to people for just watching.
Well, I like to think so. I mean, you and I devote an awful lot of our time each week to this. It's not just 45 minutes or an hour. It's hours and hours of research. And Brad and I are back and forth. You think this is a good case, think it's not, and quite a bit of back and forth there. So it is, and hopefully it is serving a valuable purpose. And we are looking for young firefighters who want to go to law school to reach out to us once they are done, because Brad and I are not getting any younger, and we've got to do a little bit of succession planning. So certainly, if there are any young firefighters out there that have an interest in it, get through law school, reach out to us, and someday you might be here holding the reins. So in the meantime, please click like, please click subscribe, please click share. All of those help us, particularly subscribe, because then you'll be notified when we do release a new recording or when we go live. And it really helps the algorithm. It's going to help us grow and, become a bigger presence, come up in people's feeds a lot more. So.
And check out our must-have policy service at
Yeah,
musthavepolicies.com.
absolutely. Can't forget that. The three-legged stool, right? We've got to have effective policies. It starts with effective policies. Then we've got to be trained in the policies, and then we've got to have good supervision. So
Absolutely.
at any rate, that'll do it for another edition of Fire Law Roundup. We'll see you all next week.